Hey everybody, Jonas Callis of the Hurt at Work Workers' Compensation Law Firm. Many of you may know me as the Workers' Comp Guy. First, the obligatory disclaimer. The following information is for informational purposes only and does not constitute legal advice to anyone, nor does it create an attorney-client privilege with anyone. So today, we're still discussing the various benefits that are available under Virginia's Workers' Compensation Act. Today I'll be discussing an important benefit in the form of travel reimbursement payments that are available to injured workers for medical appointments and vocational rehabilitation appointments. Pursuant to Section 65.2-603 of the Virginia Code, the employer and its workers' compensation insurance company are responsible for reasonable and necessary transportation costs in connection with medical treatment, and that includes reasonable and necessary trips to the pharmacy to pick up medications in certain circumstances, as well as meetings with vocational rehabilitation counselors, and that includes vocational rehabilitation benefits such as attendance at job fairs or job interviews. So, what mileage and transportation costs are reimbursable under the Virginia Workers' Compensation Act? The Virginia Workers' Compensation Act allows for injured workers to receive the mileage reimbursement for their travel expenses to hospital visits, doctor visits, physical therapist visits, visits that have been arranged pursuant to a doctor's order for diagnostic testing. And that's really the medical benefits of it. So long as it's reasonable and necessary and ordered by the treating physician, it's generally accepted as being reimbursable for the travel and the transportation costs. But in addition to those, an argument can be made that trips to pharmacies to pick up work-related prescription medications for the work-related injury can also be reimbursable in certain circumstances. So in these circumstances are, for example, some people live in more rural areas, right? And so where the injured worker is unable to pick up or visit the pharmacist to pick up the prescription medication in conjunction with some other errand or with a doctor's appointment, like say the pharmacy is 20 miles out of the way the other way for whatever reason, where the injured worker is unable to pick up the prescription medications any closer, obviously those, and does not frequent the area wherever the pharmacy is, those trips could be reimbursable. In addition, and that's especially true where the injured worker has requested that maybe the prescriptions be filled closer to home or at a different pharmacy, and that request has been denied. So where the insurance company, where there's evidence that they're not really cooperating when the injured worker is being reasonable, because arguably requesting that prescriptions be filled at a pharmacy closer to home is pretty reasonable. So in that circumstance, a strong argument can be made that the injured worker should be reimbursed for his or her transportation costs to the pharmacy to pick up the work-related prescription medications. Additionally, where the injured worker was unable, wherever the pharmacy is, if the injured worker was unable to pick up the prescription meds in association with a trip to the doctor's office, like say they don't fill prescriptions, especially at some specialists' offices are smaller and don't have built-in pharmacies in-house. So where the injured worker is unable to pick up the prescription medications at the doctor's office, and the pharmacy is somewhere else, and maybe the injured worker doesn't have transportation, or it has transportation really, but is unable to drive because of the work-related injuries or something to that effect. If the injured worker requests transportation to the pharmacy to pick up work-related prescription medications, and that request is denied, then whatever means the injured worker ends up using, like maybe it's an Uber or a Lyft, whatever means they use to get to that pharmacy to pick up the work-related prescription medications, arguably those costs, whatever they may be, could be reimbursable under Virginia Workers' Compensation Act. With regard to vocational rehabilitation costs that are reimbursable, obviously trips with the vocational rehabilitation counselor are going to be reimbursable. Typically, those visits or meetings are scheduled at a place that's fairly convenient to everyone. Sometimes it's a library or a place like that that's more local to the injured worker. So those trips will most of the time be reimbursable. But it can also, as I've stated earlier, it can also be, an injured worker can also be reimbursed for trips to a job fair or to job interviews when they're trying to get back on their feet following the work-related accident. So anything, especially if the job fairs or the job interviews are related to the vocational rehabilitation counselor's recommendations. But even when they're not, if it's a bona fide effort by the injured worker to gain light duty work within the work restrictions, and they're putting forth their best effort, arguably those costs for those trips would be reimbursable. So it may be a good way to understand it as well as to what's reimbursable is to understand what's not reimbursable, right? So the Virginia Workers' Compensation Act does not require the employer and the insurance carrier to reimburse an injured worker for mileage or transportation costs related to litigation expenses, right? Like, so if your claim has been denied, or if it's been accepted but something else, a more recent request for a different type of benefit has been denied, to the extent the injured worker has to travel to a deposition or travel to a site visit or travel to the hearing itself, those litigation-related costs are not reimbursable. That's just part of doing business. It's just not reimbursable by statute. In addition, it's important to know that travel reimbursement expenses and costs are not reimbursable where a claim has been denied. In theory, employers and their workers' compensation insurance companies deny claims on a good faith basis where they have supposedly a valid or bona fide potential reason for denying it. They're not supposed to just deny claims willy-nilly, okay? So where supposedly they have a bona fide reason for denying the claim, and ultimately they believe supposedly that they could win at a hearing and they wouldn't be responsible because the injury or the accident is not compensable, right? Then they have no duty to reimburse the injured worker for any medical treatment, and they have no duty to reimburse them for anything. They really can refuse to pay anything depending on their belief, how strongly their belief is. They may not pay anything. So in those circumstances, there's no recourse until either the worker wins at a hearing or eventually convinces the employer and the workers' compensation insurance company that the claim would be compensable, and the employer and or the insurance company agrees to that, right? And some award order is entered, or judicial opinion if it goes to hearing, right? Under those circumstances, all the past medical treatment visits and vocational rehabilitation visits, if any, would be, the travel costs would be reimbursable. So a big important question oftentimes is, well, how much can I get reimbursed, right? Like how much is this reimbursement that we're talking about? Because that's what it's all about, right? So although the Virginia Workers' Compensation Commission actually sets its own mileage reimbursement rate each year, they often actually just go by whatever rate the federal IRS, the Internal Revenue Service, uses for its mileage reimbursement rate. So, for reimbursement, transportation, mileage costs incurred in 2019, the rate of reimbursement is 58 cents per mile, where the injured worker provides his or her own transportation. Now, okay, well, I'll get to that in a minute. the commission understands, and I've kind of alluded to this earlier, that a lot of times injured workers, for whatever reason, may not have their own transportation. Where they don't have their own transportation, maybe they just don't have a car, or where maybe they have a car but they're unable to drive it because of their work-related injuries. The commission allows for injured workers, as we've discussed, to request from the insurance company and or the employer, the request from the insurance company through the employer to provide transportation to certain work injury related events. And by law, the insurance company is supposed to provide assistance in those circumstances. So how does that happen though? Like, how would that actually come about in the real world? Obviously, the employer and the insurance company cannot know that the injured worker needs transportation until the injured worker advises them that, hey, I don't have any transportation to my appointment next Tuesday with the voc rehab counselor, or I don't have transportation to my MRI next Wednesday. So the injured worker obviously would have to provide that notice, because the insurance company and the employer may not know that. All right. Related to that, here's a ninja tip that I like to provide to injured workers. If possible, it's good practice to notify the employer, and or typically at that point you'd be dealing with the workers' compensation insurance claims adjuster. But either way, it's good practice to notify them as soon as like at least 2 days in advance of an appointment, right? Like telling somebody 30 minutes before the appointment, that's probably not going to leave them enough time to arrange for transportation, right? Because people live by schedules. So it's good practice, and it shows a good effort on your part to make sure that it's a priority that you want to attend all these visits, right? And that'll be important. I'll get to that in a minute, because you don't want to miss any of these appointments and give the insurance company a reason to suspend your benefits if you have them. Okay, so in addition to advising the insurance company at least 2 days in advance that, hey, I won't be able to make this appointment because I don't have transportation that day, that notice, that advisement that you won't be able to make the appointment because of transportation issues should be given in writing, right? A letter, I guess, and it's not bad, but an email or a text, assuming you have that open communication channel with the insurance claims adjuster, is probably the best way, because in that event, you'll have kind of a record for yourself, your own evidence record. In case that comes into question later, you can say, look, here's an email. Here's a copy of the email I sent right here. This is the same email we've been corresponding with over the last 3 months. Like, they should have gotten this one. So those are some ninja tips as to how to handle these situations when you're having an issue getting to medical appointments or voc rehab appointments. Now, along those lines, obviously, if the insurance company does arrange for transportation to a medical appointment or to a voc rehab appointment, they're already paying someone to get the injured worker there, all right? So in those situations, the injured worker obviously wouldn't be entitled to any kind of reimbursement for that travel expense, because they didn't really pay an expense. It was already paid for by the insurance company, okay? But what happens, let's say, what happens when the injured worker requests assistance to travel to a medical appointment or to a voc rehab appointment, and for whatever reason it's not in time, or they get no response or whatever, right? The injured worker should make every effort they can to either follow up with the insurance claims adjuster to make sure that they got the request for treatment, or if there's another way to get to the appointment. I think that's a good way to approach it, right? Because it shows that you're making a good faith effort to attend these appointments, which cuts against the employer's argument later on that no, their benefits should be suspended because of non-compliance, right? So in this day and age, there's Uber, there's Lyft, there's Yellow Cab Taxi. There are all kinds of ways to get to an appointment, right? And if you are able to get to the appointment and save whatever evidence you have, a receipt, or print out the Uber, like the ticket for the cost that it was associated with that trip to and from, and submit that along with the medical record, if you have it, to the insurance claims adjuster for reimbursement. So that's how you would handle that. And I guess the last part I want to discuss about that is tolls, right? Um, Especially in more urban areas, tolls are just a part of life. And sometimes you have to drive through a toll or two each way to get to a meeting, especially with medical appointments, because sometimes providers are just across town or whatever. So in those cases, it's the same thing. The injured worker would be entitled, arguably, to reimbursement of the toll expenses. However, the injured worker would want some sort of evidence that they did incur the toll and paid that. So where the best practice is for the injured worker to request a receipt of what has been paid at the toll. And that way there's some sort of evidence to submit to the insurance claims adjuster with the reimbursement request. Now, we talked about this a little bit earlier. What happens when, and this is why it's so important, this is why transportation is so important, right? Because, how much money is it worth? I mean, okay, 58 cents per mile and this, but usually if you're in Richmond, you're treating somewhere in Richmond, usually, right? If you're in Roanoke, you're treating somewhere in Roanoke. If you're in Fairfax, you're treating somewhere close by because there are a lot of medical facilities in those areas, right? Sometimes in rural places, there is a little more travel required, but it's still not going to make anybody rich, okay? That said, you're entitled to it, so it is a benefit and it is worth something, okay? But another way to look at it is, what's the downside of not meeting these appointments because of travel issues, right? Well, what happens when you miss an appointment is that, as I've alluded to earlier, the employer and its workers' compensation insurance company can file what's called an employer's application for hearing. And what they can do is they can request suspension of whatever benefits you are receiving because of non-compliance issues. That goes with medical treatment and also goes with vocational rehabilitation efforts, okay? You don't want to get in this situation because you could win at a hearing, right? But what happens is it will go to a hearing, right? Once they file that, they can suspend your benefits and you'll stop receiving any kind of payment, and it'll be set for hearing. And maybe 3 months later, you'll have the hearing. Now, you could win at the hearing 3 months later, right? But in the meantime, you're going to have to figure out where your money's going to come from over that 3-month period because they're not going to pay you. So it's important. And here's the language. Section 65.2-603 subsection B. The unjustified refusal, that's what it's called when the non-compliance, okay? Quote, the unjustified refusal of the employee to accept such medical service or vocational rehabilitation services when provided by the employer shall bar the employee from further compensation until such refusal ceases, and no compensation shall at any time be paid for the period of suspension unless, in the opinion of the commission, the circumstances justified the refusal. Now, end quote. Like I said, a lot of times injured workers can win those claims and maybe get retroactive reimbursement. But a lot of times what the bigger issue is, what are you going to do in that 3-month period when you're not getting maybe wage loss benefits that are, and I've talked about this in other videos and on my website. The wage loss replacement benefits are there to approximate the wages and the earnings lost by the injured worker because of the injury, okay? So what are you going to do if you don't have that income coming in? I mean, that creates a tough situation for injured workers. And a lot of times employers and the workers' compensation insurance companies will use this as leverage to kind of negotiate kind of a lowball settlement offer, because at that point a lot of injured workers are in dire straits and they need some money. So they're more likely to accept a settlement offer that's maybe a few $1,000s short of what it should be. So you want to try at all costs to make these appointments. Because the transportation is there. Request in advance. Make sure you have a written copy of your request. And if push comes to shove, Uber there, right? If you can, right? Because you want to keep those benefits coming. You don't want to give the employer and its workers' compensation insurance company any reason to file an employer's application for hearing and suspend your benefits. Now, actually, I think that's all I wanted to cover today. Regarding mileage and transportation reimbursement benefits in the Virginia Workers' Compensation Commission. Thanks for watching my video. I hope it's been helpful. For more information, check out my website, www.hurtatwork.com. hurtatworkinva.com. That's www.hurtatworkinva.com. Also, check out our website. Follow us. Just through the website, follow us on Facebook, YouTube, Twitter. We have additional information on those sites quite often that may be beneficial. The whole point of this is to provide information which might be available if you know where to look, but it's awfully hard to find for injured workers who aren't workers' compensation specialists and who are in the middle of a claim. It's hard for people to find that. So that's why the Hurt at Work workers' compensation law firm is putting all this information out there. It's good information. It's free. It'll help people with their claim. Along those lines, if you have found this video or other videos or our website helpful, tell your friends, tell your family members. They may be going through the same thing that you don't know about, or they may have a friend that you don't even know about who's going through the same thing. And they may be able to say, hey, look, check out this website, check out these videos. They're really helpful, and they may help you get your bearings and help you know what benefits are available to you and how to best get them. So that's kind of the whole point of these videos and the website. We always believe that it's better to have the information and not need it than it is to need the information and not have it. And then you end up shooting yourself in the foot sometimes. So that's all I got. Until next time, stay safe and don't get hurt at work.